to the trivia. It's with great pleasure that I welcome back one of our probably one of our biggest fan favorites, Joy Belk. As most of you know, but in case you don't, she's a North Carolina certified paralegal and the managing director of paralegal certification for the NC State Bar, where she coordinates and manages paralegal certification. If you haven't conversed with her and you're certified, then I don't know. I email back and forth with her a lot. She's a great resource. Ms. Belk earned her BA from East Carolina University, where I'm from, but I went out of state. But yeah, East Carolina University, a post-baccalaureate, I probably said that wrong, paralegal certificate from Meredith College, and a master's degree from Liberty University. She, of course, as I said before, is a regular speaker here for the Metrolina Paralegal Association, and we're very glad to have you here virtually, Joy. So take it away.
I'm just trying to figure out how I drew the short straw to come behind Tanya. Okay. I am like, oh my goodness, because ethics is not that interesting. So I will try not to put y'all to sleep. Like I said, I'm warning you, this is not as interesting as Miss Tanya.
I want you to know that we already have people saying we love Joy. I'm
telling you, when I was so hoping this was going to be in person because I love coming but the other part of it, when I come, I'm always hugging people. And I was like, how would I be able to go and not hug people because of COVID? But here we are, and I'm still happy to be here. I love speaking for Metrolina. But I think Tanya has us all want to be investigators now. But while we are still paralegals, let's make sure we are following the ethics rules. Okay, so I just tried to share my, there we go, wait. I'm trying to share. Okay, here we go. Thank you so much. Trying to get through the slideshow, so give me 1 second. Of course, I would be the one that's having technical difficulties. Okay.
Listen, it's not a real Zoom webinar if we don't have technical difficulties.
I know, right?
Looks good on our end.
So once again, I am Joy. Please don't call me Miss Belk, just call me Joy. And I am the Managing Director of Paralegal Certification. So we're just going to jump into it. And it's avoiding situation that may expose you to UPL, which we all know is the unauthorized practice of law. That is one of the biggest no-nos that a paralegal can do. So one of the things that a paralegal we have to do in this field is we have to have attorney supervision, which means if all our work product has to be supervised by an attorney. And that comes under Rule 5.1, which requires partners of a law firm to ensure non-lawyer staff follows the rules of professional conduct. So, attorneys are governed by the rules of professional conduct. We are governed under those same rules. Everything that an attorney must follow regarding ethics is what a paralegal must follow regarding ethics. Also, Rule 5.3a requires a supervising lawyer to ensure staff is following the rules. And Rule 5.3c holds the lawyer responsible for acts of a paralegal. If a lawyer orders or ratifies paralegals on ethical conduct, lawyers must make sure paralegals know and follow the rules of professional conduct. Now, and I know I've said this before, you know, because the rules of professional conduct for us haven't changed. They haven't changed the other 2 times I've spoken with you all. So some of this may sound redundant, but it is very important that we follow these rules and that, you know, that you understand what I am saying, because if you are committing UPL, that is a serious infraction, not only for you, but for your attorney, which is why when a paralegal or legal assistant, non-attorney staff is hired, it really is imperative that that law firm conducts some kind of ethical training with the paralegal. I know a lot of us came into our jobs and it is learn as you go. Learn how to, you know, prepare a subpoena or, you know, paperwork is what we usually learn as we go. Ethics is something that needs to be taught to that new staff immediately, because it is so easy to do something that you think is innocent, right? But in actuality, you've just committed UPL, and we'll talk about some of those things. But as I also said, the lawyer is responsible for whatever you do. So not only if you're committing UPL, you're going to get yourself in trouble, you are going to get that attorney in trouble as well. So NCGS 84-2.1, practice of law is defined as performing any legal service for any other person, firm, or corporation with or without compensation. This includes wills, trusts, contracts, court filings, and estate inventories and accounting. So if somebody came to you and asked you to help them with their will, could you do so? The answer is no. Could you do it for yourself? The answer is yes. Could you do it for, say, well, maybe not. Could you do a contract for your friend? No. Could you tell your friend which document they need? No. Like when Miss Tanya was talking about right now, she's an LLC, but in 2022, she's going to be an S Corp. Could we give her advice or tell her why she would need to stay at LLC or why she needs to go be an S Corp? No, we can't. Can we even show her which document she needs to complete? No, we can't. And it's interesting because say if you're in real estate or you're a lay person, right? And you have the same knowledge we have. A person who is like a real estate agent may be able to prepare a contract for their client because they're going to sell a house, right? But we can't because we are paralegals. So we can't use our knowledge that we've attained to assist people in certain situations. And I find that, you know, it's interesting because, like I said, a person who knows nothing but about the law, who's sat around and watched old episodes of Matlock or In the Heat of the Night. I just dated myself, so y'all forgive me for that. They could tell somebody what they needed to do, but we can't. And that's something that we need to make sure that we do not do. You need to know what you can and what you cannot do as a paralegal to save yourself and save your attorney. Okay. So 2000 FEO 10 permits a non-lawyer to appear at a calendar call only to notify the court or lawyers the court of lawyers' whereabouts and availability. Like, you can't go in court and say your attorney told you to plead this for their client, right? You could just say, Your Honor, I'm sorry, my attorney can't be here today. They are XYZ. Okay, and leave it at that. And the Your Honor would say, okay, and then you grab your stuff and you leave. Okay. Preparing any filing before a judicial or quasi-judicial body. Be very careful with that when you do not prepare filings. I mean, unless, yes, we're just going to change it. Do not prepare filings, okay? Appearing as a representative of another before any court or quasi-judicial body. Now, we'll talk about this a little deeper because there are certain instances where paralegals can assist, and it's the exceptions of Social Security Administration, IRS, Patent and Trademark Office, the United States Citizenship and Immigration Services. Me personally, I'm avoiding all of that, especially with Social Security Administration, IRS, mainly because I'm scared of the IRS. I don't want to do anything to make them mad at me. So I will avoid the IRS at all possible, and U.S. Citizenship Immigration Services.
Ms. Belk, we have a quick question.
Okay.
Someone wants to know what FEO stands for.
Federal Ethics Opinion.
Thank you.
You're welcome.
Sorry,
I had to think about it a second. I'm sorry. I should have said it out. I'm sorry.
And then Sheila has a comment. Can we refer to them to BAR or NCSOS, etc. websites?
I'm sorry. Repeat that question.
Yeah, Sheila, I may need you to clarify. I think you're asking when people are asking questions, can we refer them to another resource like the Secretary of State website or the BAR website?
That would probably be the best, but make sure you phrase it like you have to make sure you phrase it in a way that you're not trying to steer them certain places. I mean, like I said, it is really just a touchy subject, but referring someone to someone, I don't see as a problem. I mean, not someone, referring somebody to a website, because you don't know. You may be able to find it here. I don't know. But long as you're saying, I don't know, tell them to Google it. I mean, I'm not trying to be funny or mean when I'm saying that, but you don't want to be saying like, if somebody's like trying to do a contract where it may be one of these, you just want to make sure that you aren't telling people, or it does not appear that you are giving legal advice or trying to point people in the right direction. You know what I mean?
Yeah, Sheila says that most of the time she just tells them to get an attorney, and that's
the best answer, Sheila. Honestly, that is the best answer. They need to find an attorney, because if you tell them to go to a particular website, that may be construed differently. I would just leave it to, you need to contact an attorney just to play safe. And also, like I said, we can do some work with U.S. Citizenship Immigration Services. But for me, you really have someone's life in your hands with immigration, citizenship, and one mistake can cause someone to be deported, be removed from their family. So, if you're going to take on these type of areas, you really need to be well-versed in what you're doing, and just be careful, okay? So also organizing corporations, preparing the articles of incorporation, preparing shareholder agreements, preparing bylaws and minutes, LLCs, partnerships, and other entities are treated as corporations for UPL purposes, which means no. You're going to be considered practicing UPL if you do any of those things, okay? So make sure that if somebody's asking you, well, can you assist me or tell me which document I need to use to start my business? And I know that you know, but the best thing to tell them is they need to contact an attorney and let the attorney lead them in the right direction. So, you know, we cannot give oral or written legal advice or legal opinion to a client. We can't interpret legal documents for a client. And as I said, the organizing corporations and preparing the articles of incorporations, we cannot do that. We cannot set fees. And that is like if a client calls your firm and needs a document prepared and wants to know, like, you know, your attorney charges $250 an hour, right? Well, let's not tell them that. Let's not do any negotiations of that. They need to talk to the attorney and they can set that out. We are going to stay far, far away from setting fees, okay? We're not negotiating any settlement agreements. And we're not soliciting legal business on behalf of attorney. So if, so you know someone who may need an attorney, or you want to go out and get additional clients for the law firm, we can't do that. Don't solicit legal business on behalf of attorney. It's like I said, it's a very slippery slope. Like if I know someone who needs an attorney, would I want them to contact somebody I know? You know, people are always going to ask, well, do you know such and such and such? So, and we're eager to say, well, I know this person, and that may not be a bad thing, but you can't go out and intentionally try to get clients for that attorney. Recommendations and soliciting is totally different, you know? So just make sure you're not putting Facebook posts out, you're not putting flyers out, trying to get business for the law firm. That is also considered UPL. So do not assume responsibilities for a lawyer's work product. So a lawyer may delegate legal and non-legal work to a paralegal, subject to any limitations imposed by statute, court order or rule, administrative regulations, or the rules of professional conduct, which is Rule 5.3. If warranted by extreme circumstances, a lawyer may allow a paralegal to sign his or her name to court documents as long as it does not violate any law, court order, local rule, or rule of civil procedure. The lawyer has provided the appropriate level of supervision, and the signature clearly discloses that another has signed on the lawyer's behalf. And that's 206 FEO 13. So if you're preparing a letter, say to a client that the attorney has asked you to prepare, and he or she wants you to prepare it for them and sign their name, you need to make sure if you sign their name that when you sign yours, below it, you put some kind of notification that you are the paralegal. Okay. You cannot send that out with just the lawyer's signature and that's it. You have to notate that you are the paralegal that's sending this letter by instruction for the attorney. In the letter itself, you may be able to put that you're the paralegal or whatever, but if the attorney is like sending it, like for me, the attorney, make sure when you sign that letter that you put, like I would, Joyce C. Belk, paralegal 2. And that way the client or whoever's getting that letter knows that you are not the attorney and that the attorney did not sign that letter. So, and this also comes with that, do not mislead others about your role. The limited capacity of a paralegal must be clearly indicated at all times, including business cards, letterhead, and websites. That's RPC 126. A lawyer and paralegal must take reasonable measures to ensure that clients, courts, and other lawyers are aware that a paralegal is not licensed to practice law. Some federal agencies authorize non-lawyers to represent parties in certain procedures before the agencies. And we discussed that earlier, immigration, IRS, Social Security. So with the limited capacity of a paralegal must be clearly indicated at all times. So I think back in the day, maybe at one point in time, paralegals, we didn't have business cards. We weren't on letterhead. They don't put us on websites. And some law firms and businesses still don't include their paralegals on a website. And I'll be honest, that kind of makes me upset because I feel like as paralegals, we are very important to firms and businesses, and that we need to be recognized. And most importantly, it also helps with identifying your role. So when I see a law firm or a corporation that has included their paralegals, I get excited personally. I'm like, okay, that's a law firm. Not saying that law firms who don't value their paralegals, but I just like to see it. And like I said, it lets the public know that you're not an attorney. And that's why a lawyer and paralegal must take reasonable measures to ensure that clients, courts, and other lawyers are aware that a paralegal is not licensed to practice law. Because you probably will get a lot of questions pertaining to the law. I always say, I'm sorry, I'm a paralegal. You need to add, that is considered unauthorized practice of law. You need to speak to the attorney. I can't give legal advice. And most of the time that would work. Sometimes you will have people like, but I know you've had a similar case. So if you've had a similar case, you could tell me, what happened in that outcome. Don't fall for it, because if you do and you tell them what this happened in this case, say they don't get as much money as the other case, they're going to tell on you. And then you're going to be in trouble for UPL. So this badge we sent out, I think about 2 years ago.
Love it, love it, love it, Joy.
Yay, I'm so happy. So this badge can help identify you as a certified paralegal if you're a certified paralegal. And what it does, it helps to not mislead others about your role. So this badge can be used on an attorney's website. It could be used on your letterhead. It can be used in your email address. Well, what is that called?
Your signature.
Yes, your email signature, your Facebook, Twitter.
We have someone asking where they can get the badge. And if I remember correctly, once I passed the certification, they just automatically sent it to me, but that was only last year. So can you help us answer how can those who are already certified get a copy of that badge for their email?
If you are already certified, just send me an email. My email address is jbelk@ncbar.gov. And I think I have, in my last slide, I think I do have my email address just in case you didn't catch it, but it's jbelk@ncbar.gov.
I'm going to put it in the chat for you.
Okay, thank you. I think this badge is one of the best things that we've done in the last 15 years of recertification. It makes it easy to identify who we are, especially in your signature, for in your emails. And this doesn't have to be just used for your job. Your employer most definitely can use it on their social media as well. But this is for you. Certified paralegals have earned this badge. So it's also can be used on your personal social media, if you like. And this is one of the most serious issues is trust accounts. I think if y'all have heard me speak before, you know how nervous I am about trust accounts. And it's not because I don't trust myself and think that I would do something like take money. No, it's just because trust accounts are one of the highest reasons that an attorney is disbarred or a paralegal is arrested. You do have paralegals who have committed UPL, and they would get a letter from the state bar saying a cease and desist letter from the state bar. But if you are doing things you should not do with the trust account, it's going to go further than that. You will probably get charges. So this is where another issue, not just with ethics, as I spoke before, but this with trust account is not one of the things where you can learn as you go. You really need to be trained in what you need to do for trust accounts. I know a couple of years ago, because so many attorneys were getting in trouble when it comes to the handling of the trust accounts, that the North Carolina State Bar and the North Carolina Bar Association came together and offered a free CLE and trust accounts. Well, as we know, most of the time, 9 times out of 10, paralegals are the ones who handle the trust accounts. So I was able to speak to Alice, who was the director of the trust account, the director of paralegal certification at the time, and asked her could paralegals also attend that CLE. So I think it was for a year or a year and a half, we were able to attend the trust account CPE given by the North Carolina State Bar and the North Carolina Bar Association for free as well. They don't have it anymore, but if you are dealing with trust accounts, I do feel like it's imperative that you take a CPE or CPE or CLE in trust account yearly. You need to stay up to date because the last thing that you want to do, trust me, I used to work in the prison system. You do not want to live there. You do not want to go there. So make sure that you're staying up to date on the rules and regulations regarding trust accounts. So, and the rule is Rule 1.15-3. The purpose of a lawyer's trust account is to segregate the funds belonging to others from those belonging to the lawyer. A lawyer may delegate management of a trust account to a non-lawyer or other non-lawyer employee, but the lawyer remains professionally responsible for the safekeeping of the funds deposited in the account and for the compliance with the record keeping and accountings required by the rules of professional conduct. And when we're saying keeping the lawyer's trust account is to segregate the funds. If you have a client and they have money coming in, right? Like they want a settlement or whatever, that money needs to be under that client's name, correct? You have to keep the money that's separate from the law firm's money. So, you have attorneys or, who may fall on hard times. Their firm isn't doing as well as it used to. So they say they're just going to borrow this money from their client's trust account, but they're going to pay it back. Okay, that's not cool. You can't do that. Even if they pay it back, they have what's the word I'm looking for? I can't think of the word I'm looking for, so forgive me. But they are in serious trouble because if they're audited, it's a possibility that they could get charges or, something else could happen to them and you. And if you assisted them in doing that, you could get charges as well.
Okay. Was the phrase you were looking for no takebacks? There's no takebacks and trust
There
accounts?
are no takebacks. It really is not. And we've had so many attorneys who, have done things like that, and paralegals. And we've had, like I said before, we've had paralegals who've done it without their attorney's knowledge. And the thing is, if a paralegal does it, and it's basically embezzling, if they embezzle the money, that attorney is held liable for that. So even if the attorney comes to the North Carolina State Bar and says, I just found out my paralegal of 15 years has been taking money out of our client's trust account, they're not going to get a pat on the back and say, oh, well, thank you for being honest and letting us know. No, they're going to get investigated. Because if you remember in our earlier slides, we said that the attorney is responsible for the supervision of the paralegal. So if your paralegal has been taking money out of the trust account for 1 year, 2 years, 3 years, then that gives off the impression that you're not supervising your attorney, your paralegal, and you are not doing an audit yourself of your trust accounts. So it still could be a possibility that you get suspended, that the attorney's law license gets suspended or it gets revoked. And as far as a paralegal, they could, if we find out, their certification could be revoked, but that's nothing compared to going to jail.
Joy, we have a question from you.
Okay.
You can tell I'm tired. We have a question for you.
Okay.
Someone would like to know, I'm sorry, I thought you might be near the end of your trust account. I apologize for interrupting then. But she wants to know if it is okay for paralegals to become guardian ad litem. I hope I said that right.
I hope you do become a guardian ad litem. I'm a guardian ad litem. And I know a lot of paralegals who are guardian ad litems. When you're a guard, and I can go back to trust accounts, but I do feel like guardian ad litems are very, very important. So I can speak from experience. As a guardian ad litem, we're not giving any legal advice. All we're doing is going into the home where their child is, and we talk to them, find out how everything is going with them, and we talk to their caregiver. Now, we do write reports, but it's not legal. I mean, we do write reports on what a child has told us. And we give our opinions, but it's not like UPL type of situations, right? And
it's more of observing and reporting, right?
Right. It's definitely observing and reporting. And we do get to go to court because the judge will ask us our opinion. So if you have a love for children, and being a guardian ad litem is great, and I do feel like it also is a great networking opportunity, because you will be at the courthouse, you get to meet the judges, you get to meet other attorneys there. So yes, you can be a guardian ad litem. I hope you do seek it out. It's a great experience. So
I think I just want to hit on one key difference there. You said a judge might ask your opinion. So they're asking your opinion about what you've observed.
Correct. I'm sorry. Yes.
They're not asking your legal opinion.
Correct.
Which of course we would never give.
Right. I'm glad you could clarify that for me. Yes, they're asking you what you've observed with the child. Do you feel like they are happy? Have you seen any red flags? Things like that. They won't ask you legal questions at all. It's just what you've observed.
Are you ready for one more question, or would you like to finish trust accounts and then we can
take one more question?
Okay. Oh, well, another one just came in. You're so popular. So Chris wants to know how independent paralegals avoid UPL issues. Do they contract with a firm? What about companies and corporations they contract with?
Now that question, if you don't mind, I'm a hold, because after trust accounts, I am going to talk about freelance paralegals, because sometimes they can be, you have people who just come out of school and feel like they can be a freelance paralegal without the knowledge. So sometimes they can be my little problem children. So I am going to talk about them after trust accounts. So
and then we have one more quick one, and it's really kind of an observation. Basically just, why would a paralegal ever agree to manage a lawyer's trust account? It seems like a minefield, which, I can see that perspective, but I can also understand it just being part of the job.
And that's why it's part of the job. Now, I've avoided it. I've avoided jobs where, luckily, the firms that I have worked for, they have been straightforward in their job descriptions. So I was able to avoid dealing with trust accounts. But there are paralegals who, are awesome. Just because I wouldn't, deal with trust accounts, because as you can tell, I might be a little scary. And the reason I'm scary is because ethics is what I do. So I just have to make sure I'm extra careful in everything I do, because it's something that I'm teaching, on a regular basis. So I know, and plus, I don't know if my more seasoned paralegals remember hearing about Bruno. Bruno used to be the auditor at the North Carolina State Bar for trust accounts. So when I was in school and they mentioned Bruno, it was like the boogeyman. So I just always want to make sure I avoided it, because they made him seem like he just came after attorneys, rah. And in all actuality, Bruno was one of the sweetest persons ever. He was probably my height, which is, he was probably 5'3", but he was he's passed on now, but he was one of the sweetest people ever that you can meet. But because he performed the audits, it just made it seem like he was bigger than life and he could just destroy your whole world. But that wasn't who Bruno was. If you were called for audit, Bruno was fair. and you just needed to make sure you were doing what you were supposed to do. But people do trust accounts because A, it's part of the job, and 9 times out of 10, they're good at it. They probably had a great attorney who really set them down and told them what they needed to do. I hope I answered your question. So for the trust accounts, paralegals often have check writing authority. They can reconcile the trust account on a quarterly basis, must be detailed and include pertinent info, deposit slips, ledger cards, and trust account checks. So as long as you can follow the guidelines, as long as you can make sure that your attorney, well, as much as you can, or nobody else, or yourself is dipping into trust accounts, you should be fine. And yep, one more trust account. So rule 1.15-2 requires every attorney who maintains a trust account to file a directive with his or her bank to notify the North Carolina State Bar of any check on the trust account that is presented against insufficient funds. So if the money is gone and the check bounces, the attorney is supposed to let us know. There are some that have not. But like I said, if there's an audit, which is truly random, a random audit, the North Carolina State Bar will find out. As I said, what's done in the dark will come to the light. And yet again, trust account. So the basics create the paper trail that tells total sum of the deposit. Make sure you have the client's name and client matter, the date of the deposit, disbursing amount, the bearer's name, date, client name, matter, and balance. If you have those things, you should be good to go. Oops, sorry. Try to get my face out the way so I can read.
Don't be sorry. You're doing a great job.
Okay.
It's always so awkward when you're presenting because it just feels like you're talking to yourself. And I don't know that people who haven't done that part of these webinars understands that it is a little bit weird.
Well, you know how you can see who's in the Zoom? Well, that's covering my my actual slide for me. So I have to keep moving it around I can read. So like I said, the audits are random. I don't know how the auditor what kind of method they use, but the audits are random. So, and it's checking to make sure lawyers are following the trust account rules 1.5-2 and 115-3. Or the audit can be done because of a grievance. Some of the times we'll have disgruntled clients call and say that they think their attorney is stealing their money. So if that's the case, then an audit will be conducted. And if your attorney gets a letter saying that the North Carolina State Bar has received a grievance regarding finances, y'all just need to make sure that you're honest and that you give the information that is required.
We just have a really quick observation. Again, somebody's talking about their firm and how their accounting department pretty much controls everything and issues the statements to the client, which is that's definitely a cool situation. I certainly know of law firms though where it's one attorney, one paralegal, and the paralegal's even cutting their own paycheck. So well, I mean that's a lot of trust, right? And that's
a lot of, and you know what? And it's that type of trust that is good, and that kind of trust that is bad. Because, like I said, I have had we've had a paralegal who the attorney trusted, and she was taking money out the trust account, and she's in federal prison. So, but having a paralegal cut their own check, that's interesting. I mean, even if there is trust, I don't know if as an attorney that would be something I want to do. But when you have smaller firms, I mean, you have to do what you have to do with a smaller firm.
That's right. I mean, you have to adapt to the situation you're in sometimes. Yeah.
Yeah, you do. So, I mean, we're honest anyway. We do, like every other profession, have a few bad seeds. But I can honestly say that in my 7, almost 8 years at the bar, I have only dealt with that with 2 paralegals who were misappropriating funds. So that's not too bad. Out of what, 4,000, over 4,000 paralegals, 2 is not bad at all.
We're a pretty good crew.
I think paralegals. So, and this is the same thing we were talking about. The misappropriation of a client funds by paralegals may result in discipline up to including disbarment to the lawyer. Like I said, it's serious and possible criminal prosecution to the paralegal. Oh, so we're doing conflicts. I wanted to get to, I thought I was getting to the freelance, but we'll do conflicts. So with conflicts is basically when an attorney is hired from another firm, a conflict check is usually performed to make sure that the attorney hasn't worked on any files that the new firm has. Most of the time, conflict checks aren't done on paralegals. They should be, especially when a paralegal is coming from another firm that is doing, and they're doing the same type of work. So it is imperative, if a conflict check is not done on the paralegal, it is imperative that the paralegal takes the initiative when they receive files to do a quick check. Make sure it's no one you have worked with before. If it is, notify your managing attorney immediately. Do not look at that file anymore. Don't touch it. Give it straight to your managing attorney or supervisor. Let them know that that appears to be a case that you previously worked on. Because if you don't, then of course that's UPL. And they want to do that because they want to make sure you're giving details on that case, which will give your new attorney upper hand. So, like I said, I used to be a paralegal for DOJ, and then I went to North Carolina Prison Legal Services. So I always had to have do a conflict check to make sure I wasn't working on a file of an inmate that I worked on a file for at DOJ, or when I was a correction officer and dealt with them in prison. So my independent freelance paralegal. What's my first little block here? More instances of UPL. So as I stated, we do have newer paralegals who come out of school or have left a law firm and decide they want to be a freelance paralegal. And they do not have the slightest clue of UPL. Or they do have the clue of UPL and care not about it. We have had some of those as well. Sometimes you will see paralegals offering to prepare child support papers, divorces, help you create business, UPL, all that's UPL. So if you are thinking about becoming a freelance paralegal, it is imperative that you attend some CPEs regarding ethics and UPL. Before you step out on your own, make sure you understand what UPL is and the professional rules of conduct. To be a freelance paralegal, you still have to have the supervision of an attorney. Okay. So you can't just say, do a post to say, well, I can help you with your divorce. I can prepare the paperwork. I could help you with your child support issues. No, you can't do that. You have to be under the supervision of an attorney. There are different Facebook groups for freelance paralegals where attorneys are a part of, who are looking for freelance paralegals. That may be a way. If you know attorneys who need a freelance paralegal, you can be in contact with them, but you have to do the work under the supervision of an attorney. That's point blank all it is to it. Like I said, it's required even if work is outside the lawyer's office. If you're working in your own home, if you're not an employee of a law firm or business, you still have to have the supervision of an attorney. All the same rules apply regarding professional conduct and ethics and UPL. Conflict checks when you are freelance paralegal is one of utmost importance because your attorney that you are working for at the time, they're not going to know what you work for, what kind of clients you've been in contact with. So this is the time where you really need to pay attention to what kind of work you're receiving from your attorney and make sure you don't have a conflict. Okay. And that's what, so you can't work for both sides of the aisle. You can't, when it says cannot do work for adversarial lawyers on the same matter, you can't work on both sides of the aisles. Okay. So you either have to work for defense, or the other. You can't work for both. And you must be screened, even if other work was negligible. And when I say, and please listen to me, you can get in trouble, serious trouble as a freelance paralegal if you are doing UPL. You have no one to fall back on. Back in the day, like I said, when I visited before, paralegals could say, I didn't know. Paralegals can no longer get away with, I didn't know. You cannot get away with saying your attorney told you to do something. This is whether you're freelance or if you're working in-house, okay? You can't get away with these things because it's too much information out here for you to know what you should and should not do. There's our website. There's the statutes. I'm giving you all the, statute, the ethics opinions. So if you're thinking about becoming a freelance paralegal, make sure you understand the rules of professional conduct. I really wish there was a CPE just for freelance paralegals.
Well, you know what? Maybe I'll make that happen because I agree.
I think it's needed. I think it's needed because especially with COVID, you had more people going that route. I think it gave people downtime and they realized that, oh, wait a minute, I can use my skills as a freelance paralegal and work from home. COVID made people realize that they want to work from home. They did not want to go in the office. And so they decided they were going to be a freelance paralegal, but they're winging it.
It's no good to wing it in any business, honestly.
Right.
But so we have a comment here. This is from Sylvia. As an independent /freelance /contract paralegal, I have actually had to terminate my contract /resign to protect myself from attorneys providing insufficient supervision of me. And I think that really speaks to the fact that we also have to, just as she said, protect ourselves.
Protect ourselves. I'm telling you, I know it's scary when, even if you are not a freelance paralegal, it's scary when you have a job and you're dependent on that income to tell your attorney that you don't feel comfortable doing something. I understand that. But it's something that's necessary. And when you're a freelance paralegal, just like Sylvia said, you have that ability to just end the contract. You know, you're not going to put yourself in danger of losing other potential contracts or being in trouble with the state bar. It's just not worth it. And there are attorneys who really trust paralegals to the point of their own detriment. And I'm not saying it's the detriment because the paralegal is shady. No, I'm saying it's their detriment because everybody makes mistakes, right? And because we aren't attorneys, a paralegal could make a mistake that could cost someone their freedom, you know, could cost someone their children because the attorney isn't looking over what they're doing. So I know it may feel good because your attorney trusts you like that, but you need to make sure your attorney is also following those guidelines when it comes to supervising you. So Sylvia, I give you a big clap on that for protecting yourself. And it's funny, after all that, these are the few things that's not considered UPL. It seems like more stuff is considered UPL than what's not. And that's true. You know, corporations may use non-lawyer employees for transactional legal document preparation. Corporations may only use non-lawyer employees for small claims court. Federal agency practice, we talked about that. Financial advice, investments, accounting, and financial statements, and general business consulting, and acting as a conduit, which means that if the attorney tells you to give somebody legal advice, then you can. But what you're going to say is, my attorney asked me to tell you this. Always make sure to say, hold on 1 second. Somebody just came in my house and they're a little loud. Give me 1 second.
I think we've all experienced that during the pandemic too, haven't we? I've got to say, we're coming up on our break and we are running just a little bit behind. Representative Clark is here. If we could, Greg, if you're there,
forgive me for that.
Christina, and why don't we do it this way? Christina, if you'll go ahead and put the passphrase for Joy's session in the chat box, that'll help us get to break sooner. And Joy, I was just saying, everybody in this pandemic has experienced somebody who shouldn't be in their Zoom, who is in their Zoom.
I'm just like, what is that? I am so sorry. But like I said, the last part, if your attorney tells you to tell someone something about their case, just make sure you are saying, my attorney asked me to tell you this. Never make it look like the information is coming from you. And that's it. So if you have specific questions about UPL, you can ask for David Johnson in the North Carolina State Bar. And we have an ethics hotline. So if you feel like your attorney is asking you to do something that you feel may be UPL, you can call the State Bar and ask for ethics. You can email ethics. All of this is anonymous. So you do not have to give your name if you choose not to. So if you want to remain anonymous, I would say call. If you don't care, then you can email. But if you want to remain anonymous, I would say call. And do we have any other questions?
Yeah, just hold on 1 second. Let me check.
Okay.
Well, this is Terry Lynn Good. She said it is always a pleasure to have Joy speak on ethics. Aww. And that is absolutely true. We are hold on one quick second. I trying to do too many things at one time. I think everybody knows how that is like too. I was just putting in the chat. Greg, if you could go ahead and put up the passphrase, that would be great. Miss Belk, I'm sorry, you said not to do that. Joy,
yes.
Thank you so much for being with us.
Thank you.
Yeah, we're touched, and I hope that you will come and visit us in person as soon, ASAP.
I want to. I can't wait. I mean, I have the best time. Y'all always have the best food.